Welcome to Vampire Divorce with attorney Clarke Young.
Hey everyone, welcome back to an all-new episode of Vampire Divorce with attorney Clarke Young. I am your host, Michael Young. Clarke here is a seasoned family law attorney. He's a consultant. He's also been an expert witness, helping courts and families navigate the realities of these high-conflict custody cases. Today's episode, we're going to be talking about why judges in these cases often resist conditional custody orders, even when they know those orders are effective. Clarke's going to explain all in just a second. Clarke, it is good to see you as always. Let's talk about what a conditional custody order is. I know they're designed to kind of tie the parenting time to the behavior. You can explain a little bit further, but why do the courts tend to avoid them in these borderline cases?
Well, Mike, thanks for having me, first of all. The conditional custody order is actually the essential tool that the family courts have for dealing with borderline cases and other cases involving moderately severe or severe psychological diagnoses, mental issues with the other party. And so when you're dealing with these cases, I guess I should say what happens in a conditional custody order. It's basically saying that rather than having just an alternating schedule, like it's a 2-week, 3-day on, 4-day the other parent, 4-day you, 3-day the other parent, that repeats every 2 weeks or something like that, or they divide it by 70-30 or 80-20% time, all those normal things that they do in every family court across the country. A conditional order is basically going to give the normal range parent, I guess you'd call them the trusted parent, if you're looking at it from the court's point of view, the additional authority to deviate to a degree away from the written order in order to achieve certain specific targets, if you will. And the target that they're really looking for, what they're trying to do in a conditional custody order, is modulate and monitor the pathogenic parent's poor parenting while emphasizing that parent's good parenting. So they're trying to reward the poor parent, if you will, the pathological parent, the pathogenic parent, when they're able to regulate themselves. And but when they get to a point where they're having a bad day or they have what I call borderline flare-up, and they just go on the rampage for whatever reason, it allows older children to call the normal range parent and say, mom's having a bad day. Can I come and stay with you and come back another dime? Or when the children are younger, there would be maybe a monitor involved, a psychologist, a child psychologist, who will talk to the child after every visitation and go through a checklist of how things went. And if some pathogenic symptoms begin and behaviors arise in the child that aren't normal range, then the therapist and the parent who has primary custody can discuss what to do, and they can limit the pathogenic parent's time with the child temporarily, subject to make-up time later. And so to get to the heart of your question, you can imagine that some judges are going to balk at that because they're going to assume that the normal range parent is going to use that to remove the parent from the child's life. And so they are very hesitant about that. The second reason is that most families don't have the financial wherewithal to be paying the child's therapist or another monitor with a psychology background, maybe a master's degree or something, licensed in clinical social worker or a marriage and family therapist, to actually monitor the situation every visitation. They're out there, they can do that, you've got to find them. But most judges are reluctant to turn over that amount of discretion to a third party. And that's really the long and the short of the answer is that it comes down to the judge needing to have a lot of trust in either the trusted parent or in the team that's been put together to monitor the mother's behavior and the child's behavior as well.
So, Clarke, given what you just said, I'm sure this creates a little discomfort for these judges. But how does the potential judicial fear of appearing punitive kind of influence the custody decisions in these cases involving this type of behavior?
Well, I don't know that the courts are so concerned about appearing punitive. I've seen a lot of judges that they'll lower the hammer when push comes to shove. Uh, the larger problem I see is fighting stereotypes, and we talked about this in a prior episode. But a lot of men go into these situations with a very negative stereotype, and it's basically they're these physically violent, emotionally abusive, psychologically dysfunctional Monday night football watching alcoholic couch potatoes that don't know one end of a baby from another and could care less. And men, normal range men, have to overcome that presumption. And I don't care if the judge is male or female. It seems to be almost universal. On the other hand, most women go in with a very positive stereotype, and that's that they're these wonderful, loving, nurturing, supportive earth goddesses that couldn't do anything, let alone think of something that wasn't in the absolute best interest of the child. And that's the real rub. I mean, you can feel this. California, like many states, has a tender years doctrine now that basically that they have statutes that have done away with it. That the presumption used to be that a child under the age of 3 or 4 really needs to be with the mother more than the other parent. And they've done away with that on paper, but it's still alive and well in practice in a lot of courtrooms. So um, again, I don't think it's a matter of them being punitive. I'm sure that from when I say I'm sure, I mean I know for a fact, sure, 100% certainty, that borderlines experience judges who don't give them everything they want as being punitive to them. I mean, the judges become the enemy. I mean, because from a borderline's point of view, there's no such thing as a neutral party. You're either for the borderline or you're against them. It's no black and white. And as soon as you say to them, I don't think you're a perfect parent, then you have somebody who's now hostile towards you as a judge. And that's something judges, I think, just have to get over and don't worry about because somebody has to tell these people with authority, someone with authority and power. Again, you're relating to the borderline on their communication channel, which is power, control, manipulation, deceit. So you can only go to power and control if you're a judge, right? So you got to relate to them on a power basis and say, I have the power, you don't. You're going to do what I tell you. And borderlines will always experience that as being punitive when in fact it's just somebody trying to uh, modulate their behavior vis-a-vis the child and the other parent, by the way, because the spousal abuse, the psychological spousal abuse and spousal neglect is as great or greater than it is towards the child, and the courts don't recognize that either.
Clarke, we talked about this in a previous episode, but it kind of piggybacks on what you were saying. What, why do the courts, in your estimation, prefer this vague cooperation language over what could potentially be these enforceable conditions, even after they've seen repeated failures of the cooperation?
Well, I think we've addressed that pretty much. I mean, the it comes down to the again, the statutes have a presumption that 50-50 custody is in the best interest of the child. I mean, it's that silly. It's that stupid. It doesn't take reality. And then you have to, the party who wants to deviate from 50-50 has the burden of proof to show either by preponderance of evidence, in some cases clear and convincing evidence, that it's in the child's best interest to deviate from 50-50. So it's an uphill battle for a normal range parent, just under the law, to get there. There's nothing in the law, in the statutes, that says unless there's a demonstration that the one parent or the other or both have moderately severe personality disorders or character flaws, whatever it may be. So that's just the universe we're working in, and you just have to, how can I say, muddle through the process in order to get to a just and fair and healthy result, despite how the system's set up.
Right. Clarke, have you seen a resistance sometimes to conditional orders, and it tends to prolong litigation and maybe even increase harm to the child?
Well, that's a simple yes. I've only ever been able to get two, my whole career, two conditional custody orders, and they worked really well, by the way, but you're always fighting that, and it's always there's always resistance towards that. I mean, judges, again, they just don't want to go to the conditional custody order. To them, it's like a last resort. And from my frame of reference, it's the first tool you should pull off out of the tool shed. You should go right to that, where there is upfront on day one, credible, substantial evidence that one party suffers from a moderately severe personality disorder.
Yeah.
So to me, the judges are looking through the wrong end of the telescope, and until and unless the system changes to where it starts treating these cases much like they do domestic violence restraining order cases, people are going to be courts are going to continue to destroy these families financially, psychologically, emotionally, and generationally. It'll take 3 generations for these families to recover from what the courts are doing to this one generation. They don't get that.
Clarke, I asked you this in a previous episode, but I'm going to kind of reframe it a little bit, given what you just said. So the light bulb goes on, right, for the judge in the case. They finally accept that the containment is working more than what the consensus, right? What tends to happen then in that regard? Like, are judges coming to you afterwards and saying you were right all along? Like, what would you want the system to do? You mentioned it about, hey, this is the tool you should use first as opposed to last. Is it as simple as that?
Yeah. Yes. Well, let's assume we did the long haul case, and it's now 2 years down the road, and the light goes on. You will see the courts aren't going to apologize, and you don't want them to. That's not what they're there to do. But what you'll see is they'll suddenly say, they'll turn to you as counsel and say, okay, I denied your request for conditional custody order twice before. And I'm going to do a subscript here. You will never, ever get the custody orders you need when you need them. The courts are always going to be 2 to 3 hearings behind. And that's just a practice pointer for every attorney out there, for every litigant. You're never going to get the order you need when you need it. You'll get it later. But then on that date, they won't get the new order that you need. They'll give you the old one that you needed. So there's a lag in the system by 2 or 3 court appearances on these things. But in this hypothetical, you now have the court having denied 2 requests for a conditional custody order. Now you're there in the 3rd time, and now they're ready. Well, then you set it up, and it's everything we've talked about before. You have someone who can deal with the parent alienation issue, that can actually do reunification and recalibrate the relationship of the child with the perhaps alienated parent, or even they're alienated from their siblings or whatever it is. It's somebody who has the skills to even work with someone who has borderline personality disorder and have them realize that they're not out to get the borderline parent. They're their best friend. They are the gatekeeper. Excuse me. They're the gatekeeper to getting the borderline parent back into the family as a unit, because
Right.
you want the family functioning as a unit to the extent that it's possible with the borderline. And that's the ultimate goal. So when the judge realizes that, and I say this all the time, the other party's the problem, my client's the solution. And at some point, Your Honor, you're going to get that. You're going to see that. And when you do, this is what I'm going to be asking you for. And they look at me with this like, who are you kidding attitude look in their eyes. But I'll tell you, after 2 years, they're talking to me like I'm their long lost friend.
Well, Clarke, let's put a bow on this and let's talk to that parent who's listening to this and they've also watched courts hesitate to act decisively like you've encouraged them to. So what would you want them to understand about patience, timing, how these decisions do eventually shift their way?
I think that's really the client care part of this. You have to manage their expectations. You have to educate them about how dysfunctional the family court system is with respect to these kinds of cases. You have to let them know that there is a team supporting them to win. You have to let them know how expensive it's going to be. You have to give them a realistic timetable about how long it's going to take for the light to go on for the judge. And for me, the hardest thing is, especially with older children, explaining to them that honestly, their children are going to be psychologically maimed for life because at age 12, 13, 14, I'm sorry, the borderline's magic the spell has been cast, and you can't dispel the spell. And that's always painful, but it never ever stops parents from sacrificing everything else in their lives to try and save their children at least 2 or 3 years of the same sort of psychological maiming they've been experiencing since birth. Mm-hmm. So it's a hard road to hoe as an attorney. I mean, you have to be strong for a lot of people, and you have to make sure the client understands that that things that are going on inside and outside the courtroom are all being handled.
Yeah. It's well said. Clarke, thank you so much for the time, the insights, and breaking this all down as always. I appreciate it.
Thanks, Mike, for having me.
That's it for today's episode of Vampire Divorce. If you want to learn more, you want to connect with Clarke and learn all about his work as not only a family law attorney, consultant, but also an expert witness in these high conflict custody cases, do me a favor, visit clarkeyoung.com today to connect with Clarke. Thanks again for listening. Before you go, hit like, hit subscribe, leave a review, comment, share the episode with someone that needs to hear it. I am Mike Leon. We'll see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.